May it please the court. Shane Cohen is asking this court to reverse the order of the district court upholding the search that occurred in this case and asking that it be remanded with instructions that the motion to suppress be granted. This was a bad search. The cases are fairly clear on what the inquiry, or not fairly clear, they are clear on what the inquiry is here. We look at the factors in their totality, and we would submit that in their totality, this Detective Beckwith did not have reasonable suspicion to prolong the stop, and certainly did not have reasonable suspicion at the point that the stop ended to continue to detain Mr. Cohen and for the purposes of searching the car.
When he patted him down, felt a bag of heroin. Would that change your mind?
Well, Your Honor, the government and we don't disagree on much in this case, but we really do about the search.
I understand, but
yeah.
I just want that one question. I want to know if during a pat-down, we can
Yes,
decide
sir.
whether the pat-down's legit, but
Yes.
If during the pat-down he felt a bag of cocaine in there, would the officer have reasonable suspicion?
If in the context of this case, no, but in general,
Any person who has cocaine probably has probable cause to arrest, doesn't he?
if he can tell it's a bag of cocaine.
Yeah. He suspects there's a bag of cocaine in there, and he can't be certainly sure, but all we need is a reasonable suspicion, articulable suspicion, and he concludes that it's a bag of cocaine packaged in a bag there, and I was trying to focus on whether you're challenging the blunt wrappers as legitimately considered to be drug paraphernalia.
Thank you.
That's one issue at that point.
Yes.
The second issue is whether there was consent
Right.
when he got out of the car and raised his hands. And it seems to me those two events sort of shape one issue in this case, and that's whether he had reasonable suspicion to extend. The other question is really the Farrier question, is that even if it's just an ordinary traffic stop that ends when he hands him his driver's license, it's extended by a couple of minutes when the news comes in that there's a warrant for his arrest, whether that implicates the Fourth Amendment. And those are the two issues for my purposes that I think need to be addressed most.
Okay, well, yes, sir. Okay, so with respect, and to try to answer your question directly about the blunt wraps, our position, of course, is no, that feeling blunt wraps or cigars, whichever they are, it's not really clear from the record whichever they are, it's a legal product. It does not, in this case,
I can't tell you how many cases we see up here with blunt wraps. That's the way marijuana is smoked often.
How about tell me what a blunt is? The best definition I could find was that it was a hollowed out cigar, but I don't know if that's, just tell me what it is.
Yeah, I'm not sure. There's a brand of cigar that you could buy at any convenience store, which perhaps is what Mr. Cohen did in this case when he pulled into the convenience store, called Philly's Blunts, and they are cigars. The government
It's just the wrapper part.
apparently
Then
Beckwith says two different things. Beckwith says they're cigars, and he says they're wraps. The government, in its brief, says that blunt wraps is a euphemism for marijuana. This is not in the record, obviously, but I got on the internet, I Googled blunt wraps, and it takes you to tobacco sites.
Well, it is because the blunt wrap is tobacco. But to have if you're smoking cigars, you're never going to have a wrap. You're going to buy a whole cigar. The blunt wrap is the large leaves that are used to wrap, and you stick the marijuana inside the blunt wrap and smoke the marijuana. And so that's what the officer said. I've never seen blunt wraps except in connection with marijuana.
Yes, that is what he said.
So am I correct that it's a hollowed out, for lack of a better term, cigar?
I'm not sure, Your Honor, because again, you can buy something called Philly's Blunts, which are cigars, which have tobacco in them. So it's not clear from the record exactly what Mr. Cohen had. Beckwith at some points does, I think it's in his written report, and I think also in his testimony at the suppression hearing, he says both cigars and blunt wraps. So our position is that he's in possession of a legal product. That by itself cannot rise to reasonable suspicion that he is in possession.
You go into a house and you see scales on the kitchen table. That's legal.
Mm-hmm.
But in the context, officers often conclude that that's indicative of drug paraphernalia because of the context in which they find it. So I'm not sure that answers the question. It seems to me is we would look as to whether a reasonable officer in this man's position and in the context would conclude that a blunt wrap was being used for drugs.
Well, if you conclude that, then this case is going to hold that nervousness combined with possession of a blunt wrap is reasonable suspicion.
Well,
because
also
at that point,
admission that he smoked marijuana.
at that point in the stop, that's all Beckwith has.
He also said he'd been arrested for
Arrested for marijuana possession. Yes. Yes. Yes.
And we're in a drug area where the officer said this was a common area where.
I would briefly like to talk about the consent part of it because I think that's very important.
Well, was that challenged in the motion to suppress? My understanding was the motion to suppress only addressed what occurred after the traffic stop was concluded.
That's correct, Your Honor, but the magistrate judge found that it was an illegal
But that
search.
wasn't challenged by the defendant.
It was challenged by the
Legality
government,
of
yes.
that was not challenged.
It was challenged by the government.
Not challenged by the defendant
Correct,
in his
Your Honor.
motion to suppress.
Yes.
Okay.
Yes. But what I would like to say to that is if you look at the record, in Beckwith's narrative of the stop, and also in his written report of the stop, and the district court's order, it is referred to that Beckwith asked Mr. Cohen if he could search him for a weapon. So that if arguendo, Mr. Cohen consented to a search by going like that, he's saying you can search me for a weapon. All right, and for Beckwith then to go beyond that is going beyond the scope of consent, and we would argue for that reason the search fails as well. But again, in the totality, yes, sir.
How do you know he wasn't searching for a weapon? That's a pat down. He can legally ask the passenger or the driver to exit the vehicle.
For his safety, yes, he can.
And at that point, wouldn't it be natural for an officer, if he's going to do it for his safety, to pat down for a gun?
For a gun, but he certainly had no reason to believe either a cigar or a blunt wrap, especially a wrap, would be a weapon.
Pat down, right?
He did. But he had no basis. I mean, that could have been, for a plain feel, there's no indicia that that's anything. What it shows is it's not a gun. I mean,
So he has to ignore anything else he discovers during the pat down, even though he's searching for a gun, but finds some contraband. He has to ignore that.
I would say if he feels something that is a wrapper that couldn't possibly be a weapon.
Well, that's the secondary question.
Yes.
Whether that's what I was asking you originally, whether the officer could reasonably believe that this was drug paraphernalia. But let's assume it's clear it's drug paraphernalia.
Okay.
Something else. And he's patting down for guns, and he finds drug paraphernalia. Officer can rely on that, can't he?
I would say he could, yes, but again, I would think wrapping papers would be
I understand
pushing
that
it.
argument.
Yes, okay.
It's not.
So in our position simply is that in this case, the combination of factors are very, very weak alone and certainly in combination. He was in a high crime neighborhood. No, he drove into what was a high crime area according to Beckwith. He made a right turn into it. He made a left turn. He stopped at a gas station. He was there for a minute. He pulls back on the Highway 117. There's nothing in the record indicating that's a high crime area. So he goes into it. He comes right back out of Of course, he's under investigation by Beckwith at that point. I mean, Beckwith is investigating him before the stop even happens in this case, because Beckwith pulls over and observes Mr. Cohen while he's in the gas station. The nervousness in this case, I think, is very understandable given Beckwith's actions. If anything escalated in this case, it is not Mr. Cohen's nervousness, it is Detective Beckwith's actions. He pulls Mr. Cohen over, presumably tells him, do you know why I stopped you? For following too close. Takes his license back to the car. In his written report, he says he tells him before he takes the license back that he's only going to give him a warning citation. So he goes back to the car. Mr. Cohen is sitting in the car. He comes back and tells him to get out of the car. So what's going through Mr. Cohen's mind at that point? No wonder Mr. Cohen became upset. What's going on here? Why are you doing this? I thought you pulled me over for following too close. You told me you were going to give me a warning ticket. Now you're telling me to get out of the car. He then tells him to get in the patrol car. And Detective Beckwith is wondering why, when he tries to engage him in conversation about the North Carolina Tar Heels, that Mr. Cohen remains nervous. I think anybody would remain nervous in that situation. I myself, I've accumulated a couple of tickets in my time. I've never been asked to get out of the car.
Still practicing law?
I am. Yeah, I've never been asked to get out of the car. Certainly I've never been asked to get into a patrol car. And again, that is what is emphasized by Beckwith throughout this. Beckwith says from the very beginning, I wanted to find out what was going on with this guy because he seemed nervous. And not to try to repeat an argument that was made in the Vaughn case, but really to affirm this search, to uphold this search, this court has never held that nervousness by itself is sufficient.
Here's my
sir.
problem.
Yes, sir.
And I've had this problem ever since I got on this court, and it's nobody's fault, I guess, but my own. When you have a different judge conducting the evidentiary hearing, as happened in this case, the magistrate judge is sitting there watching the officer, assessing demeanor, and rules in your favor. And then the case goes before a district judge who I guess is doing exactly the same thing the three of us are doing here today, right?
Looking at the cold record.
Looking at the cold record. And the district judge pulls this finding of consent out of the record made before the magistrate judge. I just don't know how I can touch it. All this talk about reasonable suspicion is really beside the point, isn't it? The district judge made a finding of consent here. Consent to the search. It wasn't a Terry pat-down. According to the district court, as I read the record, it was a consent to a search.
To a search of the car?
To a search of the person.
Of the person, yes.
Yeah.
Yes, sir.
So it doesn't matter if I'm right, and maybe I'm not. It doesn't matter whether the blunt felt like a weapon or what is a blunt. I mean, I'm missing something. What am I missing?
Well, again, our primary argument is that the magistrate judge got it right. There was no consent.
But we're reviewing the district court.
Yes.
And how do we do that? We're not reviewing the magistrate judge, right?
Correct, Your Honor.
So how do we say the district court was clearly erroneous? The law clearly permits the district court to make findings of fact, including credibility of the officer, without ever having seen the officer testify.
Yes, sir.
I'm sorry.
No, go ahead, Jeff.
Is the evidence contested? Is there any contrary evidence?
I think the dispute, Mr. Rogers may disagree with me on this, but I think the dispute evidentiary-wise is whether there was consent to a search or whether the search was good.
Which is a legal conclusion based
Yes.
on the facts, but
Yes.
the facts aren't contested.
I think in terms of what happened, yes, I don't think we're disputing
Right,
that.
there's no dispute
Right.
about that.
Right. And Judge Davis, not that I want to defend the district court, but again, the magistrate judge did determine that both Beckwith and Ward were credible. So I believe that would be the district court's basis to say they're credible witnesses even without hearing them.
Didn't the district court draw an inference of consent? Are you saying
Yeah.
that the magistrate judge also drew an inference of knowing consent to the search?
No, the magistrate judge did not.
Exactly, but the district court did.
Yes.
Was that
The
permissible?
district court disagreed that this was not an invitation to go ahead and search his entire person.
More than an invitation, the district court said it was a consent.
Yes.
Well, we have
Yes.
two cases that say that, don't we?
Exactly. So,
I mean, legally, if somebody's asked about whether you have anything on, you can check, and the guy goes like this, don't we have two cases that say that's implied consent?
Implied consent, yes.
but not as a matter of law, because the magistrate judge says it wasn't.
Yes, Your Honor.
Didn't the magistrate? So it's not a matter of law consent. It's a legal conclusion based on facts. And here, it's an inferential fact. I mean, don't you agree? Whether his raising his arms was an expression of consent is a factual determination. Some judges, hearing this officer's testimony, taking the totality of the circumstances, might say yes. Some might say no. But ultimately, it's the district judge's call here, isn't it? Not the magistrate judge's call.
Well, again, and my time is up.
Yeah.
May I answer the question? Sure. If the court is going to find consent, I would just say one thing about that. These search cases talk about how you have to take the context in which everything happens. And I would simply ask the court to do that in this case. He asked him, can I search you for a weapon? So if you're going to find that he consented to anything, he consented to a search for a weapon. All right. And if there are no further questions, I will reserve
You've
my
got some time reserved. Let's
Thank
hear
you.
from Mr. Rogers.
Good morning. May it please the court. My name is Joshua Rogers, and I represent the United States. The officers who discovered the contraband in defendant's vehicle acted upon a reasonable suspicion when they extended the search of his vehicle, or extended the stop by 2 minutes. And in doing so, the district court was correct in holding that they did not violate the Fourth Amendment. First of all, with respect to the duration question, defendant concedes that the stop was justified at its inception. And that's important because it's essentially uncontested that the officers were entitled to investigate the stop in accordance with D. Giovanni.
I'm really confused. Is this an extension of the stop case, or is this fresh reasonable suspicion case?
Well, the defendant makes the argument that the duration was unreasonable, and he also makes the argument that there was not reasonable suspicion. So we're addressing.
What do you say?
We say, first of all, that there was not an unreasonable duration because it was 2 minutes past the point that the stop
So
concluded.
you don't contend that there was fresh reasonable suspicion?
After the point at which the officer issued the ticket,
Yes.
there was plenty of reasonable suspicion at that point. The officer had all they need to call the
But
K9
that's
unit.
not your principal argument.
Our principal argument is
Is
that
duration.
not duration and reasonable suspicion. I mean, they go hand in hand. It's a Terry argument that the defendant's making.
No, I'm asking what is the government's theory here?
Our theory is that the officers had reasonable suspicion to extend the stop 2 additional minutes to call
But
K9
that's
unit.
what, I'm sorry. You don't need reasonable suspicion to extend a stop. If you have reasonable suspicion, you can make a new stop. You can make a new detention. And that's what I'm trying to just clarify.
Well,
Do you concede that the traffic stop ended?
we can see that the traffic stop ended when the officer said, "Have a nice day."
Have a nice day. So at that point, I guess your theory is, you have two separate theories. One is that it wasn't a new detention, it was a continuation of the traffic stop, even though the traffic stop had been concluded. The 2-minute rule,
Yes, Your Honor.
right? The 2-minute offense. And then I guess the other theory is that actually at that point, have a nice day, but the officer had reasonable suspicion to believe that there were narcotics in the car. Is that, I don't want to make your argument for you, I'm just trying to understand, because this is very muddled. in my mind.
And it is it's in some ways difficult, but in part because of the way the defendant has made the arguments that the duration was too long.
You keep saying the defendant makes the argument. The burden is on you, the government, right, to prove the validity of a search that is conducted without a warrant, right? You agree with that?
Yes, Your Honor.
Okay. So what is your theory as to why this warrantless search was permissible?
The officers had reasonable suspicion to call a canine unit based upon what they learned in the initial stop. So there was an initial stop.
Okay, that's what I thought you were saying. So there was an initial stop of the vehicle, sort of a classic traffic stop, during which he consented, and in the words of the district court, he actually invited the officer to search him.
And part of what creates the confusion is that the initial stop in some ways has, it feels like it ends when the second background check comes back because it's part of the first stop, at which point defendant is arrested.
Now you're saying it's part of a first stop. Okay.
No, I'm not. I'm saying that it contributes to the feeling of confusion where you're like, where exactly does this end? I mean, it ends. We conceded below, and we say it today. It ended when he said, "Have a nice day." Defendant was saying that having to wait that additional amount of time was unreasonable. We're saying it's 2 minutes. You didn't have to. I mean, that's the minimum amount of time. But either way, the officer had reasonable suspicion to call a canine and begin an investigation into drug activity when at first he had only been investigating a defendant who was following too closely.
Okay. All right. I thought that's what the government's position was, and I appreciate your articulating it with that clarity.
It is worth noting that we wouldn't even be having this discussion if the officer had simply waited until the second check had come back. That's just as a practical point. Under D. Giovanni, he had the right to wait for that, but the officer just moved forward, wrote the ticket, and at that point, there was a 2-minute wait, and then the arrest warrant came back. With respect to reasonable suspicion, there were a number of different indicators that wove together to create the fabric of reasonable suspicion that included being in a drug trafficking area, which we know that because Officer Ward testified to the fact that there had been a number of other undercover operations in the neighborhood, and she dealt with a lot of individuals in the area with narcotics violations. There was also the nervousness of the defendant, which stands out in particular to this officer, as he mentioned in his testimony, because the defendant had been told, "You're just getting a warning," yet that doesn't calm the defendant down, which tells this officer there's something more this defendant is concerned about than a ticket. He also almost immediately admits he's got a criminal record. The officer's assurances don't help him, and as the court noted before, there are blunt raps on the defendant's person.
Tell me what those are.
Well, in the record, the officer testified. They were asked, the judge had the same question, the AUSA. She asked, "Can you please describe for the court in your experience with blunt wrappers, what is their typical use?" And he's describing blunt wrappers, and she asked, "What is it? Can you tell me what they are?" He says, "Yeah, they're not actually, they're like blunt wraps that you might roll tobacco with." And she says, "I don't know what that is." And he replies, "It's like tobacco paper, but it's like cigar paper." Okay, we understand that's not perfectly clear. If the court would like, I can proffer. I spoke with the AUSA and asked, and I'd be happy to proffer for the court what it was, and it was, in fact, like empty cigar wrappers. They were rolled. You can see how this kind of gets...
What's the officer feeling when he is patting this person down? I mean,
I think something that feels more like a candy cane, and something that feels less like...
He felt 2 of them.
And that's in the... Yes, sir, that's in the record. So I spoke with the AUSA, and it's something that is a hollow candy can feeling object that's like a cylinder and not...
Start with a cigar and take out the guts and fill it with marijuana. Is that it? The theory?
Yes, sir. That is the theory. So that was what the officer felt during the consensual pat down. We would argue that when the evidence is reviewed in the light most favorable to the United States, there was reasonable suspicion to justify the additional 2 minutes of the investigation or the new investigation on the basis of reasonable suspicion. And unless there are any further questions, I'll take my seat and ask that this court affirm the district court in every respect.
not quite.
Okay. Thank you.
I correct, this evidence is uncontested.
Yes.
What the officers testified to is uncontested, and they're found to be credible.
Yes, Your Honor.
Okay. That's just what I want to confirm. Okay. have anything else you want? Okay. All right. Mr. Gordon, you have some time in reply.
Thank you, Your Honor. 2 points only. First of all, the record, I would submit, is clear on what blunt wraps are, to the extent that this court can find that he felt a hollowed-out tube or a hollowed-out cigar. We don't. The testimony is
But
wrappers.
he explained he felt 2 round blunts there.
He called them cigars at that point.
Right, at that point.
Yes.
And then he was asked to explain, and at page 37, he does explain that they're like blunt wraps you might roll tobacco in, or roll tobacco with.
Correct.
I don't know what that is. The question, I don't know what that is. It's like tobacco paper, but it's like a cigar paper. Okay, where do we have those? In his pocket, pants pocket. And he acknowledges that they had not been filled with marijuana.
Right. Well, we don't know what they are. The government didn't introduce them at the suppression hearing, so we don't know what they are. We know they're called blunt wraps. The second thing, just to try to make clear, our position is, with respect to when reasonable suspicion must exist in this case, if it exists, it has to exist at the point that he tells Mr. Cohen, have a nice day. The stop is over at that point. He has finished his business with respect to the stop, and any further
What
detention.
happens in a hypothetical situation where you have a traffic stop of normal length, and even with the 2 minutes, that's normal length? Your argument is even once it's over, though, the officer brings it to a conclusion, it can't be extended unless he has reasonable suspicion.
That's correct.
So in this case, the government argues that there was a normal traffic stop of normal duration, and during the course of that traffic stop, the officer uncovered information or received information that gave him a reasonable suspicion that something was going on. Now, if the officer tells him, here's your license, you can go, have a nice day, it seems to me the officer at that point, then they often do that, and they say, listen, can I take a look around the car?
Right.
And a lot of times the driver says, okay, and they offer cocaine.
Right, unfortunately.
Yeah. But in this case, he said no.
Right.
And so the officer says, well, I'm going to get a dog. And the question is, did he at that point have, accumulatively, enough evidence to give him reasonable suspicion to justify bringing a dog, or was the dog just a gratuitous fishing expedition?
All right, Judge
And
Niemeyer.
it seems to me that's the core of the question.
Yes, and I think we're on the same page, actually. My position is yes. At the point that he says, can I search your car? Okay, well, I'm going to bring the dog in. At that point, he must have reasonable suspicion.
Well, he says I had it based on all of these.
Correct, and I'm saying that if
And
the...
so we have to evaluate whether that amounts to enough.
Correct, and I just wanted to make, because there are, when the report came back that there was a warrant on him, when Lacey Ward said, I remember
Well,
this guy, that's all afterward.
Discuss.
Yes,
But let's assume that after he ended, the guy gets out of the car, he gets into his own car and starts driving away, and the officer hears the report, there's a warrant for that man's arrest. At that point, the officer could go back up, stop him, and arrest him, right?
correct.
Okay.
Yeah, and if that's getting into inevitable discovery,
Yeah,
what I would
exactly. That wasn't discussed by both.
And what I would say to the court simply is this: that was not brought up at the suppression hearing. There was no chance to litigate that. Does, for example, if you are arrested in Warsaw, is the habit of the police to then impound your car? There would be no need to run the dog at that point if he's got him arrested. Do they impound the car? If so, in this case, they would have discovered before
Well,
they
at the point
searched
they
it.
can arrest him, then
Right.
they can, the arrest, how much they can look at in the arrest. The Supreme Court says maybe you can look right in the immediate area
Right.
for reaching a gun, but that gets factually intensive. It's a safer process to get a dog.
And he's in the squad car by this
Yeah,
point, by the way.
to get a dog, and when the dog alerts,
Yeah.
now he can look in the vehicle.
Yeah.
Okay.
But this was not litigated. So, and again, so, we would ask the court to find that in this case, the factors in combination are simply too weak to support reasonable suspicion. This case would come very close to holding that nervousness by itself is sufficient. The court has never said that. We urge the court not to say that, and we ask the court to reverse the order of the district court. Thank you very much.
Thank you, Mr. Gordon. We'll come down and greet counsel and then go into our next case.